We are here then on Hall versus GMS Management Company, and as well as bringing in the Barberton Municipal Court and the Ninth District Court of Appeals judges. This panel is sitting by assignment from the Supreme Court on the Ninth District Court of Appeals. We are here. We're going to proceed with appellant's argument. Sir, you've argued in front of us before. You understand that you have 15 minutes to argue. Is there any, what amount of time would you like for rebuttal?
Well, if it pleases the court, I might, about 10 minutes?
Well, you get 15 minutes. Do you want 10 minutes for rebuttal?
I'll make 15, Judge. I'm sorry about that.
Oh, I'm sorry. You're going to have an initial period to argue. If you remember last time, you were able to speak. The other parties are going to be able to speak, and then the rules provide that you get another opportunity. How much of that 15 minutes do you want to hold back for what they call rebuttal, what we call rebuttal?
I'll say 5 minutes.
5 minutes would be good. All right. All parties, we have counsel for GMS is going to argue. Is that correct?
It is, and I hope the court doesn't mind me using a headset.
Whatever helps.
It's certainly not going to mess my hair.
Under these circumstances, whatever you can do to make this
Thank
easier.
you.
Good.
Thank you. I'm easily distracted. Thank you.
Counsel for the Attorney General, who is representing the judges of the Ninth District, you are going to argue. You intend to argue?
Yes, Your Honor.
Okay, and then we have counsel for Barberton Municipal Court. You intend to argue. Is that correct?
Yes, Your Honor.
All right. So we have 15 minutes for each of you as well, if you need it. And then, so we'll proceed. Mr. Hall, you have your 12 minutes to begin with.
Yes, sir, Your Honor. First of all, I'd like to bring to attention to the court here the order that was given to me on Judge Rowland, that is, on the 27th. It's an incomplete document, Judge. She has down here October 13th, 2020, and October 28th, plaintiffs amended a complaint. I didn't file the complaint on either one of those dates. That order is totally wrong. I filed my complaint on September the 10th, time 11:37. Also, I filed the amendment complaint was on September the 11th, 11:34. So I motioned to the court to dismiss all charges brought by GMS Management or anyone else because incomplete order, which has been in effect from January 27th up until this point. Again, I motioned to the court that my name be cleared and that they had no sufficient evidence. I never received any evidence, documents from the appellee, GMS Management, or his counsel. I also motioned to the court that the panel appeal court, Ninth District, never received any documents other than the documents that Mr. Hall, Appellate James Hall, provided. Also, I never received a certificate of service from GMS Management about any documents other than the two documents, which was December the 3rd, 2019, and June 4th, 2020. And I feel that this court, the two courts there, Barberton Municipal Court, never recorded any documents from appellate GMS Management, any documents signed, complaint signed by GMS Management or his attorney on James Hall. No documents was transferred from Barberton Municipal Court, as I had to pay $175, I think it was, to have my transcripts and everything transferred over to Akron Municipal Court. Now, that to me is discrimination. Whether you want to hear it or not, that's discrimination. I paid out my pocket. GMS management hasn't sent no documents to James Hall. And as you see in my notes, everything I said in my notes is true, even in terms of going to federal court. And I'm going to do that. But the thing of it is, this is unfair. Judge Rowland here, she put out an order in January 27. And as you look at your order there, you'll see they got me down here for October 2020, 13, October 28, 2020. There's nothing in the court's records in Summit County that James Hall have filed a complaint in them days of that month. I motion to the court also, if you would please, that on the other, I don't know if it's appropriate, but I'm gonna say it anyway, for to get a decision on that counterclaim, which was December the 9th. There was no documents. When I subpoenaed in January, was the time, January 7th, 8:48 to Barton Municipal Court. They sent me documents, Your Honor, which did not have anything stating about moot, which the appeal court wrote that they dismissed my appeal because I moved out July the 29th. And that's a lie, see? And so that, with that to show that they had no documents, my understanding that when you file a document, each party get a copy. The court get one, the appellee, defendant get one, and I keep one. But I never received it. So that's why I say I motion to this court to dismiss the case today, because there's been a big mistake here, false accusations on part of Judge Rowland. And I never got a hearing. When she dismissed the case on 27, she never gave me a hearing. Now, my understanding is you have to have 6 months. If no activities is on the case, then she gets dismissed it. She dismissed it in 4 months. That's violating my civil rights and also discrimination. Now, if I have to pay, if I have the rule sets for me that I have to go 20 days, if I don't go 20 days, go 21 days, my case is dismissed. This man went 5 months without filing the brief. A year and 5 months without filing any document. Now, as me being a black man, and I'm using a race card here, as me being a black man, now, why didn't I have the same rights? I was not entitled to the same rights. So I may not get what I want here in the state court, but I'm going to federal court. So I'm not done. I'm not done at all. See, because all I asked for was a fair trial, a fair hearing, and I got not either one. Now, at least Judge Rowland could have said, I'll send him a letter. She said by the phone she could have called. Now, I know I'm not a lawyer, but I'm not a fool either. See? So that's why I say I will take this another level, because what I was done unjust. I'm not crying on your shoulder, but the facts are right here. Barberton Court did not record, did not receive anything. I can stand on it and be firm on it because I didn't get it. Each time I sent you a letter or sent the court one, I sent it certified. If not certified, I sent a certificate of service. Now, he's a professional. Now, he couldn't do that. So now I'm going to say again, I motion to the court to dismiss this case as soon as possible, because the judge had made a terrible mistake here, an error. And also she got in here, no documents. She has no documents showing anything from GMS management. Nothing. If that's wrong. So again, I want to go with another motion is this. I didn't get the proper say in the court in the state of Ohio. I know that the rules, I've been doing my own reading and research. Ohio Supreme Court, if they've governed anything by our forefathers, they should have governed this. Now, the mistakes have been made here. And immunity, there's no immunity here. Because this was constantly. See? Now, we elect officials to get on the bench, do a job for everybody. See no colors. But somewhere along the line, somebody got sidetracked and seen some colors. Well, I'm not sidetracked because I want to be noticed that I will and I am going to federal court with this. And
Mr.
whatever your
Hall.
decision is,
Mr.
that's
Hall,
it.
you have about a minute left. So if you want to, with that in mind, sum up, please.
Yes, sir. Yes, sir. Again, I asked the court to dismiss this case. And if you're looking at the document that I'm looking at, the order, under those grounds, I asked to dismiss it and honor my complaint that I filed September the 10th and September the 11th. Because I know I'm entitled to it. And I'm not believing any or none of them from my complaint. Thank you.
Thank you. All right, counsel for the GMS, why don't you go ahead? You have 15 minutes if you need it.
Thank you. I cannot tell if you can hear me or if I'm muted.
We can hear you.
Thank you. I'm totally confused about anything I am to rebut because I'm not sure what appellant has addressed. So let me do two things that I think I can do. Number one, our argument is so concise that it needs no further statement. We'll rely on the brief. And still, I needed to be here because I was going to say, irrespective of what appellant argued, that there are legal issues to be resolved, but there's a problem to be resolved. Else all of us or some other people in black robes, as we just learned, are going to be hearing this. So with the court's permission, I think the problem is we need a discussion with Mr. Hall. And I'll try to make this all relevant to what he said. I made some brief notes here. I'm not sure what he's talking about never getting a hearing. I'm not sure what 4 months versus 6 months he referred to. I'm going to guess that maybe if someone files a suit and doesn't perfect service within 6 months, it could be dismissed. He somehow related that to not having a hearing. I don't think that his self-study of the rules has brought independent and self-study has brought him to the point where he might realize, and to my frustration over 46 plus years of doing this, we don't always get a hearing in the trial courts. Summary judgments may be disposed by brief, motions to dismiss under 12b-6. I can only guess that's the hearing he said was deprived to him. Now, again, I was going to discuss something that would hopefully end the problem because I think it's inherent in our arguments. Irrespective of whether, and the record is clear here now, a position was taken and there's a estoppel by pleading, so to speak. Irrespective of whether the underlying fact he moved out on the 29th of July or the 3rd of August, as long as a party is out, even if the date were wrong, the case is mooted. Again, I did not study the docket for this, and I apologize to the court. And now that we're in argument, certainly I'm up in Cuyahoga County often. The late Mr. Charles Lally used to be a court administrator, staff attorney, and he would have appellate pretrials. He died unexpectedly, and what a loss to the community. Somehow, I don't even know if it's appropriate. And I'll volunteer to be there also. But this matter is just not going to end with a judgment by this panel for us, against us, in any way, shape, or form. And I'm trying to urge I'm an advocate. I can only advocate for my client. I don't want my client continually in unending litigation with the same party. So I think what we need to do is, without repeating myself, our argument is clear. There are no facts by which liability against my client, Mr. Ogden, counsel for trial counsel for my same client, could have been liable. And I think the court ruled properly, the trial court ruled properly, and that's why we're here. But I urge this court, either in its decision or somehow administratively, if it's appropriate, to somehow get the parties together, because, and I'm addressing the court, not counsel or pro se appellant, creative and critical thinking on the rules is sometimes not fully and competently done in independent study. And this matter has to end. So having heard that there's yet another court, and the concept, for example, of res judicata, claim splitting, I could go on, but it's not necessary. My point is made. I'm an officer of the court. As I said, this is 46 years of doing this. Plus, if it's appropriate to say it now, I'll make myself available whenever the court needs me to try to get this matter done prior to, after a ruling. Thank you.
Very good. Thank you.
And I hope I followed all ethical rules in what I just said.
Thank you. We appreciate that. Any questions from the judges?
I have none.
No.
Thank you. Counsel, Attorney General Office, on behalf of the 9th District Court of Appeals judges.
Thank you, Your Honor, and may it please the court. My name is Michael Walton, and I, along with my co-counsel, Zachary Holscher of the Ohio Attorney General's Office, represent the appellee's 9th District Court of Appeals judges in this matter. Your Honors, I'll be brief. This case is very simple. All of appellant's allegations towards our clients are of actions that they took pursuant to their judicial capacities as appellate judges. Accordingly, immunity attaches, and any claim that is brought by the appellant was properly dismissed by the trial court. So unless there are any questions from this panel, we would rest on our brief.
I have
Thank
no
you.
questions. Judge Gwynn,
I have no questions. Thank you.
Judge Wise.
No, sir. Thank you.
Thank you. All right, then that brings us to Barberton Municipal Court. Counsel, you have 15 minutes if you need it.
Thank you, Your Honor. Emily A. Ambrogno, representing Appalese Barberton Municipal Court and the 3 judges and magistrates who have been sued in this matter. Like the other 2 appellee parties in this case, I think our brief very well outlines our position here. Just very basically, my clients were properly dismissed by the trial court because they're judicially immune from all of the claims in this case. All of the claims or actions alleged by the plaintiff around judicial actions taken by my clients. That includes issuing orders and determining whether they would admit evidence. So clearly they're immune from any claims brought against them. Moreover, simply stated, Barberton Municipal Court cannot be sued. It's not sui juris, and the case law is mentioned in our appellate brief. The court has exclusive jurisdiction over any claims brought against the state of Ohio. And a municipal court like Barberton Municipal Court is an arm of the state of Ohio, as are any of the entities or persons working for it, including the judges and magistrates who have sued in this matter. Therefore, this claim should not have been brought in the trial court. It would have properly been brought in the Court of Claims. And finally, the complaint just simply does not allege any cause of action against my clients. Perjury cannot form the basis of a civil lawsuit, and I really can't tell otherwise what claims the appellant might have been trying to assert. Today he mentioned a violation of his rights. I could only imagine that that may be an equal protection claim, and an equal protection claim can't survive on the pleadings unless there's some allegation that an individual was treated differently because of a class he's in. There's simply no allegation that appellant as a Black man was treated any differently than someone of a different race or other protected class. So for those reasons, unless the judges have any questions, I will go ahead and rest.
Judge Gwynn,
I have no questions. Thank you.
Judge Wise.
I do not. Thank you.
Thank you. All right, Mr. Hall, you are last up with your rebuttal. You indicated you need 5 minutes, and you have 5 minutes.
Yes, sir, Your Honor. I heard most of the conversation here, but I object to counsel, what they just said. They're immune to my complaint, but the law is that they have the filed documents. They wouldn't have it there. Why didn't their clients record? Why didn't they send certified notices to the appellant? Now, why would you have that issue and not govern it and follow it? So I disagree. Now, I never received it. I'm appellate court, for instance, let's go with the appellate court, David Yost's office, saying that, okay, they're immune. They know the law. They know that if I didn't get it, a document in there, then I would be disqualified. My case would be dismissed. It states it. So I'm no fool. So I'm not buying it. I'm not buying it. So no, we can go to the state level. I'm gonna take it to the federal level, because no, and the other gentleman that says, well, we have a conference. I'll just do a conference, but I'm giving you my state of mind right now. See, I'm 77 years old. I've been around, I've been in the courts, I've been in the federal court before, and I don't mind going again. So now I'm motion to the court, dismiss the case. I'm requesting motion, dismiss the case. The judge is already, she made a mistake here. She slandered me right here again when she said I filed on the 28th. No, I didn't. Now, this is the document. No, I'm not looking at another hearing. She done made a mistake. All they asking is time. No, I'm not for that. I'm not for that. Now, you done me wrong. Whether you accept it, that's up to you. See, but I'm going to court. When you're done with this decision, I like the decision you gave me on the 9th, December the 9th. You didn't have no documents. You didn't have no proof. Because the court sent me, Barberton Court sent me nothing relating to the cases. See? So now why, and when I first got on the phone here, they said this is being recorded. As a matter of fact, I would like a copy of this conversation. I'll pay for it. I want it. I'm motion for a copy of it.
Well, it's available. It'll be available on YouTube, Mr. Hall.
Okay, well, I want it, Your Honor. No disrespect to you, but this is what it is. Because see, it's been getting this here run around, but see, I got time. I got a lot of time. So now, my motion is dismiss the case. And with all due respect, they want to buy some time. That's on them. Because be ready, because I'm going to federal court. That's where I'm going. And that's all I have to say.
All right, very good. With that, then, we have this argument is concluded and the matter is deemed submitted. Thank you to everyone for your participation. We'll issue a decision within the next few weeks.